in our experience, actually, what he's trying to say is one of the primary factor in cross-border litigation is also resource allocation. That's what he was trying to say, where you allocate certain resources, you plan the resources. There's a cost factor involved where you are hiring external counsels. So we are moving from single jurisdiction level, where that's a normal traditional lawyer, as we do that as well, but as a cross-border lawyer, we move towards multi-layer jurisdiction. Okay, and there again he was talking about cultural variances, where we talk to different lawyers cross-border from Israel, from US, from UK, where common law system, civil law system, and here the Sharia law. And talking about UAE, in my experience for so many years here, we at UAE are at the epicenter of combining all these laws together. We use civil law, common law, a combination of it with the base of the Sharia law. We have various jurisdictions, of course, the local courts. Apart from that, we have DIFC, as we were talking before about it in the morning, and then we have the ADGM. So you see, we are basically interacting with different people cross-border, where their way of handling things is entirely different, and our way is different. Like handling here, sometimes time is a key factor here in the UAE, and disputes may be resolved faster compared to India. Because I practiced in India before Bombay High Court, and I know myself how it drags on and pulls on. Though we have fast track courts there as well. We have fast track courts, but there it depends again on our lawyers, our expertise again there. How we expedite the justice delivery system and how we whatever. I will not go into that. Well, we're coming back to cross-border perspective. Yet another factor in cross-border litigation is the factor of cultural nuances. Coming back to it, cultural nuances. Why we are talking about cultural nuances is the civil law countries basically like to think of resolving disputes. I wouldn't use the word shortcut, but they prefer resolving disputes swiftly. The same thing is here. But the common law countries, as we know, is governed by judicial precedents. They prefer studying the judicial precedents, having the base of it. Now here's the thing in the UAE, depending upon our backgrounds, from which country we come, or even with our experience here, we are like, okay, let me now think like a civil jurisdiction lawyer. Let me now think like a common law jurisdiction lawyer. Let me now come back to my own jurisdiction. Now for this, harmonization is the key. That is what he was talking about. Harmonization is the key. Where two lawyers from different jurisdictions, in our experience, can get into loggerheads. Why? All are experts. All are experts. So harmonization is the key, where we understand their point of view. We try to, as I said, wooing justice. We try to make them to understand our point of view, and then render that particular justice, whatever is required for the client, or whether you're even in-house, that is for your own company. So on that note, I'd like to really gain insight from my colleague here, Mr. Philippe, on certain procedural variances, and even in his experience in South America, or even the Middle East, Turkey, and so on, whether he could throw some light on that area with respect to certain problems that you might have faced in your experience while you handled cross-border litigation.
Thank you. And yeah, problems is I guess what we handle every single day. Let me give you maybe start a little bit by explaining what we do. That can give a little bit of light on how problems arise in the line of work where I provide advice to. So my business, or the business I work with,